Hi, friends. The topic of our discussion today is contract law, and it's a very important subject for all of us to study because it's a substantive law, and the in every aspect of life you will realize that we seem to be reaching an agreement to do whatever we want to do, and that agreement then is results into a contract if enforceable in law. And you will realize that in almost every relationship except our relatives and friends, in whether it's employment law or it is any other law, wherever we deal with, whatever aspect we deal with, it is a subject which we have to understand in our day-to-day life. It is, as I said, substantive law, and I will start giving you the background of the Indian Contract Act. Before its enactment, contract law covered almost all branches, including partnership, sale of goods, whatever. But when the framers commenced when the framers started drafting this law, they decided that they shall keep the subject of partnership and sale of goods separate from it. And I shall shortly come to what they did later on in enacting several other statutes. Now, friends, the framers, when they were deciding to draft the law for India, which ultimately became the Indian Contract Act 1872, they borrowed the its provisions from various other codes of other countries. The man mainly responsible for drafting, and his inputs were very acknowledged, was Sir James Stephen, who was also responsible for drafting Indian Evidence Act. Now, Indian Contract Act does not profess to be, it is not a complete code. And wherever its provisions are not, they don't deal with a particular subject, the courts then borrow the principles of equity, fair play, justice, and of course, principles and precedents of English law as far as they are applicable to Indian society and circumstances. Friends, the Indian Contract Act is, as I said a moment ago, is not a complete code. The framers decided that they shall keep the Sale of Goods Act and partnership separate, and therefore this act was left to deal with agency, bailment, and including the sale, other aspects of sale and dealings. But the framers then decided to enact separate statutes. And those separate statutes were, for example, after its enactment, the separate statutes were the Negotiable Instrument Act of 1881, Transfer of Property Act 1882, Indian Railways Act 1890, and Power of Attorney Act of 1882, which has been deleted. And such separate statutes were then enacted following the enactment of Indian Contract Act 1872. Friends, after the coming into force of the Indian Constitution, the Indian Contract Act continued to be in operation by virtue of Article 372(1) of the Indian Constitution. We should all know and I must emphatically assert that we should all know this, that any provision of Indian Contract Act which is inconsistent with the fundamental rights as enshrined in the Constitution will be held violated, will be void by virtue of Article 13 of the Constitution. Now, friends, as I said, this act had to be, uh, you know, brought up to date in line with the developments that were taking in Indian law. And therefore, in 1958, Law Commission of India, under the very, very able stewardship of an eminent jurist, M.C. Setalwad, made certain recommendations. And those recommendations were that, and I will read them, those recommendations were that modification, number one, modification of the doctrine of privity to entitle a third party to be able to sue on a contract which had been made for his benefit. The second was, which was very important, recognition of the principle of promissory estoppel. Third was to make an agreement enforceable even without consideration and keep the offer open for a definite period of time. And to make the wagering agreements and collateral agreements unlawful. And friends, to include the principle of material alteration. Now, let's understand this. We have always said material alteration in the documents must be rejected. And therefore, Law Commission said to include the principle regarding material alteration to documents. And the sixth recommendation was to permit reasonable restraint in the right to carry on the trade. Friends, later on, in 1984, Law Commission made another recommendation, and that was the recommendation regarding specific amendment relating to the prescriptive clauses. This was accepted by the framers, by our lawmakers in the year 1997, and Section 28 was inserted and amended to accommodate the recommendation of prescriptive clauses. Later on, our Law Commission further made some recommendation, and that was to make the promises enforceable even though without consideration, if they were acted upon, and gave limits for operation of promissory estoppel. Friends, again in 2006, Law Commission recommended dealing with the substantive procedure, substance and procedure of unfair terms in the contract. Friends, I will now like to explain to you Friends, while we are dealing with this, let me say that it is very, very important for future judicial officers to note that the extent to which the Act deals with a particular subject, it is exhaustive. And as Honorable Supreme Court held in the case of Bhagwan Das Govardhan Das Kedia versus Girdhari Lal Purushottam Das and Company, that it would not be permissible to import the principles of English law to divorce the statutory provisions unless the statute is such that it could not be understood without the aid of English law, or where any matter cannot be brought within the provisions of the Contract Act. You will all understand that we cannot begin to make references to English law because our Indian Contract Act is comprehensive enough to the extent to which it deals with a particular subject. Now, it's very interesting, friends. Let me explain to you that if you understand Section 2 and its subclauses, then you understand almost the entire spirit of the Contract Act. What is it? Let's see. It's a very common. It's something of a common sense. Let's say that somebody wants some other person to give his assent or to do something or not to do something, and therefore what he says, as we do always, man makes a proposal to somebody. In English law, it is called offer. In India, we call it proposal. That's what is the subclause A. What is the purpose of making a proposal? The purpose is that we want to get that other person's assent. What is that other person? Who is that other person? Offeree, to whom we make an offer or to whom we make a proposal. That offeree, if he or she gives the assent, then that becomes a promise. Obviously, that's clause B. And now that two parties have been created, there is a proposer, there is a offeree or a promisee, and therefore that person, now there is a promiser and there is a promisee. And what is the background of this? Friends, in general, nobody accepts, nobody, does something for somebody without some consideration. So law recognizes that there is consideration. Of course, I will come later on to where I will say that in family relations, in blood relations, there is no consideration because we do every day. A mother does something for you, a father does something for you, you do something for your father, or a wife does something for you, you do something. So in those relations and in social relations for friendship, I take you for a coffee, you take me for a coffee. There is no consideration, but in normal relationships, there is a consideration. And when there is a consideration, it leads to an agreement. And when you joined law class in the very first class, when the contract law was taught to you, you were told what is a contract? An agreement enforceable at law. So if that's so, now an agreement has been reached, it has to be enforceable. Friends, there have to be some other clauses that we deal with. That subclause F says there could be a reciprocal promise. Now, what's that reciprocal promise? Generally, a builder sells you a flat and says, I also agree to repurchase it if you like to sell it to me after a year, 2 or 6 months at a certain price. That becomes a reciprocal promise. Now, friends, there are basically some contracts which are void, some contracts which are voidable. And void is dealt with in subclause G, voidable is in I. What is void contract which is not valid in law? And that is, let's say I say to you, I will help you make some profit in purchasing the shares or selling or in dealing in the shares by astrology. Now that is absolutely, law will not recognize such contracts, even if you accept my offer and enter into a consideration. The consideration could be 5,000, 10,000 rupees or 1,000 rupees or whatever. Then, friends, H is contract, which is an agreement enforceable at law. Voidable is where you could, if you like, at the option of the promisee, you could say you will not accept the contract. And then there is avoidance of voidable contract, which I will deal as I come to the sections. That is subsection J. Thank you, friends. We shall deal with it later.